Dear students, let us start the discussion on 06th February 2016 newspaper. So in relation to this, the first article is about Convention on Supplementary Compensation and Civil Nuclear Liability in India. This is the most important article. I want you to have a total concentration in reading this article. I have provided you the comprehensive notes with regard to this article today. Please go through this. Now, internationally, there are three conventions that guide the people towards the civil nuclear liability. One is Vienna Convention, which was come into force on 1977. In 1977, it was drafted in 1963, and then we have Paris Convention, and the third convention is CSC. So the countries which are not part of the Vienna Convention or Paris Convention, so they can sign the CSC Convention if their national law is in line with the provisions of the CSC. India is not a part of the Vienna Convention, not a part of the Paris Convention, so it has signed the CSC. So what is the law that was said to be in line with the CSC? That is CLND, Civil Liability for Nuclear Damages Act of India. So Indian government claims that the law is in accordance with the CSC. What are the provisions of the CLND? Now the section 4.1 and 4.2, what it says is the operator is at no fault liability. So no fault liability means either fault belongs to him or not. The operator is completely liable. Yes, this provision is very much in line with the CSC. And the second thing is, it provides for a compensation. So the operator's liability is up to 1500 crores and the maximum liability is up to 300 million SDRs. So above 1500 crores, the government will pay the remaining money as a compensation. And over and above 300 million SDRs, the compensation shall come from CSC. That is Convention on Supplementary Compensation. This is what is the arrangement now. Now in this case, what are the objections? There are sections 17 and 46. The section 17 says about right to recourse. So right to recourse means operator, he can recourse to the suppliers and take the claim from the suppliers. For the faulty supply of the devices, he can sue the suppliers in simple form. It means the right to recourse indirectly brings in suppliers into liability. This is what is objected. And the section 46, it brings in the suppliers not only under the purview of the CLND for the nuclear damages and all the other laws for time being which are existing in the country. So the legal conundrum or else the legal complexity is very high in India that exposes them to the further risk. Then what is the governmental explanation for this? Yes, the right to recourse is just an enabling provision and it is mandatory. It means that if operator and supplier signs in the contract about right to recourse, then only it will be applicable. It is not applicable as a compulsory provision. And with regard to section 46, as section 4.2 says that operator is at liable, so it means the section 46 will be applicable only to the operator, not to the supplier. Now coming to the Convention on Supplementary Compensation. So it's a pool of money which a country can get in the case of a nuclear damage. Now, what are the objections of the left? India is diluting its CLND to provide for more security to the nuclear suppliers. So it means the Bhopal-like gas accidents can repeat in India and supplier can escape without any compensation. And if you take about Japan's example, the burden finally was on the government. It was to the tune of $46 billion after Fukushima nuclear reactor accident. So in this context, so India is diluting its civil nuclear liability law and the secrecy, that is what has been questioned. And the second thing is, India is talking about India nuclear insurance pool. So what is this India's nuclear insurance pool is? Under this, the government will be contributing 750 crores. The 4 public sector undertakings plus general insurance company will be contributing the remaining thing. So through this, the operator liability of 1500 crore rupees will be covered. So India insurance pool, nuclear insurance pool, it is something India is talking about. So in that way, we are making a comprehensive nuclear liability. So this is what is about the law. So read the notes carefully, and if you have any doubts, please pose that again. Coming to the vocabulary of justice, again, it is about the issues related to the minorities. So let us take a brief background. The section 377, it punishes any sex against to the natural order or intercourse against to the natural order. So the Delhi High Court dismissed it against to the privacy and dignity of an individual. Then Supreme Court of India in Suresh Kumar Kaushal versus Naj Foundation case, it has upheld the section 377. Now in this context, the author argues that how faulty the Supreme Court judgment was. So he says that, so the Supreme Court has said only few people will get affected by this judgment. So the Supreme Court is a counterfaction against majoritarianism, and the fundamental rights are guaranteed at the individual, and they are central to the human dignity. And the second thing is, the Supreme Court is not taking away their rights, but it is only prohibiting certain acts. An act and a person and his dignity cannot be separated from each other. That's what is the second argument. Third most important thing is, he explains something called as human dignity. What is the meaning of it? Now if you see, this becomes a very important for your ethics case or ethics understanding. So what the author says is, irrespective of a person's contribution to the society or contribution to the others, the human dignity, it rests on recognition of physical and spiritual integrity of the humans. Now, if I sit idle and read a book, I am not doing anything. So the society has nothing to do with it. And the spirit of human dignity, what it says is, the individual has to be valued as a member, irrespective of what his contributions to our society are. And it recognizes that a person is a free being who develops his body or mind as to his wish. And if he goes against to the will of the society, or if his private will goes against to the will of the society, in his personal sphere, he shall not be restricted for. So, the human dignity talks about the autonomy of the private will. Human dignity talks about a free being at most body and mental level. The human dignity talks about value and worth of individuals, irrespective of what they contribute to the society. So these are the things which I want to take into consideration. Already we have discussed about section 377 in previous videos. In the last week's videos, you can go through them. So this is the centrality of the article. The language is a bit tough. Just you read the notes which I am giving, that is more than sufficient for this. And next is the case against Ashok Chavan. Now here, the governor has ordered for the prosecution against the chief minister with regard to this Adarsh Housing Society scam. So the first is, there is a quid pro quo. The quid pro quo means the chief minister has got certain advantage indirectly, and for that he has offered certain advantage to this commercial entity. So in housing society, his relatives have got the flats. In return to that, he has given certain concessions from the government to it. So that is what is the first complaint, and we call this as quid pro quo. And the second is, there is a clear nexus established between Mr. Chavan and his relatives gaining the benefit from Adarsh scam. That is what is the J.A. Patil Commission's recommendation. Above all, for me the issue is more related to the corruption. In the case of corruption to order prosecution against any public servant, a permission from the government of the day is necessary. It is generally kept as a provision to protect the honest officer. But however, most of the dishonest people or many of the corruption incidents, they try to take the cover under this particular provision. The previous governor, Shankar Narayanan, he has rejected the permission for the CBI to enter into the prosecution against Mr. Chavan. Now, the present governor has given the permission. It means that can the incidents of the corruption can they change to the changing circumstances of the government of the day or changing circumstances of the people in the constitutional positions? Can't we have a predictability of the law irrespective of the person who is sitting over there? Next, coming to MG Narega. Now, a critical analysis of MG Narega, if you take about one way the delay in payments and lack of sufficient budgets has slowly decreased its impact from 2011 onwards. But on the positive side, it has decreased the distress migration to the urban areas, increased the real wages on the rural side, provided for improved livelihoods at the time of drought to the rural people. So in this context, MG Narega has no parallel in the world as a welfare measure. So a rights-based welfareistic approach which is demand-driven is central to MG Narega. So a demand-driven, the terms we need to remember are a demand-driven welfareism plus a rights-based approach to development. So these are the concepts which we revisited through the MG Narega in India, and it has become more successful to be implemented across the world, and World Bank also said to that extent. And GM Mustard, now it is just I want you to understand what are transgenics or transgenic crops, what are the challenges with the transgenic crops, and what are the food security concerns with the future. And ease of doing business, how it has to be improved. So, the existing tax structure has to be improved. And also the government has to focus on the reduction of the fiscal deficit. But it shall not be at the cost of the capital expenditure. So it has to take forward its disinvestment agenda at a faster pace. And through the efficiency in expenditure and decrease in the non-merit subsidies, India can bring in. And also, the corporate social responsibility, it has to be, provided streamlined in the country. So in these circumstances, the manufacturing sector, without impetus to it, we cannot achieve the growth which we are aiming for. So the Make in India campaign, though it has started, did not take off really. So we have to work for this too. These are the important aspects of this article. So thank you very much, and focus on nuclear liability law. So read that notes carefully once and twice. Thank you very much.